Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me. Dati mihi Anglican por in service of
Now I'm back. Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. There we go. Welcome to Sloth Life. First in chat this morning. Oh, I like these lights this morning. Let's just keep it like that. I like these colors. I'll save them for a little while. Congratulations, Sloth Life. I have not yet gone to the post office. I know I have a package. I have a package there from you waiting. Oh, the lights changed. What good does the lock button do if you can't lock the lights where you want them? That one. Lock. Let's see if it stayed this time. All right. Good morning. It is great to be here. Welcome. Welcome to almost all of you. Samantha, what was that about? I mean, I know what it was. I'm just laughing. that some people wake up and their go-to is just, I hate myself so badly. How can I make other people hate me as bad as I hate myself? And that's where they go to. So, Samantha, thanks for you can permanently take care of that one. Oh, Josh got it. All right, welcome. All right, Done Civil Law, Kurt, welcome. Let's see. I need a hit. Do you have any of that law? The good stuff. Hey man, if you got the cash, I got the goods. So we'll bring you a little bit of law today. We've got a couple things happening today. First of all, before anything else.
Mike. What day is it, Mike? Guess what today is?
It's Hump Day.
Hump Day! Welcome to Wednesday. We made it halfway through the work week. Whew. We're there. We hit the midway point. It wasn't very good. You remember what Mom told you? To always give me 2 thumbs up? I got a mixed. I got a mix. Yeah, he's like, yeah, that wasn't worth 2. 7 out of 10. That's generous, Kim. That was generous. It is Hump Day. Yes, we celebrate that with a little yell every week. And we'll do that. We have there's news all over the world of true crime. Okay, and we're gonna skim across and touch a little bit of it. We're gonna do a little bit of court hopping. We're gonna go to the Karen Reed hearing, which is supposed to be the spiciest part today, but that doesn't start until 11. So we've got about an hour before that starts. Anyway,
happy birthday! You look good.
Oh, you're right. Judge Fleischer reminds us that we have some birthdays to sing to. Those would be these wonderful people right here. Is it Elena? It's going to go with Elena, Leet Mum, Tish, and Meg. Tish, that's our Tish. Like I claim ownership on Tish. Tish is one of our moderators. Elena, Leet Mum, Tish, and Meg are all having their birthday today. Not Elena. Elena? Eliana? Oh my goodness. Eliana? You know, let me just take this moment. There are authors out there. You might think, why am I talking about this? I'm coming around. There are authors out there who are fantastic storytellers, who can spin a tale that will keep you captivated on the edge of your seat, turning each page, never wanting to sleep. Just you've got to finish the book. There are authors out there that are that good. I cannot read them if they have names of characters that just don't make sense pronunciation-wise. and most things don't make sense pronunciation-wise to me. So, Eliana, there we go. We're going to Eliana, I apologize. Your name does not make sense to me. I'm going to try to say it right at least one time, and that's during the song. Because you deserve to be sung to today, along with everyone else who has a birthday. Eliana, Leet Mum, Tish, and Meg all celebrating their birthday. Everyone, please stand up where you are. Take a deep breath. Shoulders back. Project your voice to the back of the room. Blend your voice with your neighbor. Warm up with me, if you will. La 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 la. There we go. I was watching Billy Strings this morning, picking and grinning on the guitar, and need a birthday version of that one. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Eliana, Leet Mum, Tish, and Meg. Happy birthday to you. I said Eliana. Is that right? I got it right. Thank you. To everyone who celebrated their birthday today, congratulations, first of all. It was your special day. There are many wonderful days throughout the year. This one is yours. The privilege, the pleasure, the honor of you choosing us above every other location, every other person you could celebrate with is all ours. Hopefully we can return that to you, make your day a little more special, or help yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's,
You look good.
Bob Evans, Tammy Dunlap's house, and Andy's Grill. There we go. I need to write that list down somewhere. Triel, is it safe to come in? Has he already done the hump day yell? Yes, I did. Pancakes are on the grill, says Tammy. Tammy, I love that we can add you to the list of free pancakes. And here's the funny thing. I kid you not. If you went to Tammy's house, she would give you free pancakes. That's no joke. That's just who Tammy is. She's amazing. Let's see. 80s Music Band got too close to the dancers. Almost got high kicked in the face. That's a risk you take. The alternative is the peach version. And I'm just saying it could be worse. The kicks are not the worst thing that could happen. Are waffles also possible? I would say I'm vacillating on that, but today especially I'd say I'm waffling on that a little bit. Yeah, we'll do waffles today as well. Happy birthday to everyone who's celebrating. It's exciting to have a birthday. It's exciting. And today's yours. Happy birthday. Judge Fleischer, do you want to weigh in on this one? Does anyone want to...
Make sure you're my best friend.
Okay, that was close, but let's see if Judge Fleischer can... Here we go.
Shame on you, sir.
Happy birthday. You look good.
There he is. There's Judge Fleischer. Thank you, Ricky C., for getting that for me. Drum solo? Big finish. It crept up on me. All right, let's see. Virginia says, my birthday is on the 10th. Getting older than dirt. My brain just doesn't accept it. It happens. Let me tell you, before we start talking about the amazing things that are happening in the world of true crime and all the developments and such, let's tell you this. I have weather alerts in my area, and the weather alerts have like little things that don't really mean much, like scattered tornadoes and things like that. 60-mile-an-hour winds, and they're measuring the rainfall in inches. So I don't know what's going to happen this afternoon, but definitely the Mother Nature is going to put my 115-year-old house to the test, and we'll see if we're able to live stream through all of it. But I might have to get the generator out. So we've only had one tornado within, I don't know, it was probably 2 miles away. Came 2 miles away, and it was probably, I don't know, probably 10 years ago. It destroyed a couple houses. But so we have not tied down our trampoline. We have one in the side yard. We're anticipating donating the trampoline today to someone else. We don't know who. Just whichever way the wind blows, they get our trampoline. Yeah. So some bad weather. This is basically what started down there in Texas about midnight yesterday morning, and then it's just moved across the country. So this is our turn. So, all right. Did your meteorologist say if the ground would be hard as a rock? I should probably check in. I have not heard that anywhere other than Canton. But quick update on some of the things that are happening in the world of true crime. Specifically, there's newsworthy that might be interesting. I know we did not follow the Harmony case, but we followed Adam Montgomery's firearms case, and he is now asking for a new trial in the murder conviction of his daughter. So that's he's trying to come back. I don't see that happening. I don't see it happening, but throw it at the wall, see if it sticks. We've got the Donna Adelson. Her bond was denied. She's got the charges regarding her son-in-law, Dan Markle. Let's see. Brian Koberger's case. New filing we expect. If it hasn't dropped already, it will drop soon. That the defense is asking for the death penalty to be thrown out, but for a new reason. They're actually saying you need to throw it out because he's on the autism spectrum. That's going to be an interesting. I wonder why it waited this long to come up with that. I wonder if it took that long to find a doctor who would diagnose it. I don't know, but so that's going to be happening. He wasn't even present at his trial. Hope they say no way. Yeah, you don't get a second chance if you didn't show up the first time, right? Yeah, just crazy. I don't see him getting a new trial. I don't know. Stranger things have happened, but the odds are not in his favor. A couple people I need to mention and call out by name, starting with Carrot Bringer. Good morning and happy hump day, y'all. 6 months. Congratulations on that yellow courthouse, Carrot Bringer. Love it. Stephanie, member for 12 months, gets the orange courthouse. Says I'm orange. All right, in chat, you guys are amazing. On to the next year. Time flies. It's wonderful. Gigi, member for 11 months. Good morning. Happy birthday. Court hopping hump day. Yes, it is. Debbie F. Cook, member for 3 months. I missed y'all so much. Hey, RA and chat. Debbie, it's good to have you here. Thank you. Hope you're doing well. Gracefully Broken Mom is here. Welcome to the gallery. And Babs Austin, member for 18 months. Zippity doodah, zippity day, another 30 to be exact. And how lovely it's been. Love my addict friends. Thank you very much, Babs. Appreciate it. Wouldn't be the same without you here. Appreciate you being here. All right, we have, let's see, is there anything else? Every year I need to give the state of the stream address. Straight Pickles, obviously. It may coincide with some other state of the addresses, but not related in any way. I like to reserve that for April 1st, Greeners. Is that a good day to do the state of the stream address? I might need some help crafting that. Who's going to be my speechwriter for that one? And if you have a really good idea for an April 1st live stream, let me know. Red Pen's like, fine. Fine, I'll do it. All right. I was thinking this morning about what we would do April 1st. And I think we have a court case going on at that time. Is that Karen Reed? I think that's Karen Reed right there. Speechwriter ChatGPT. Let's see. You did send me, Josh. I'm gonna say no on that one. That court has gotten. First of all, the audio is killing me out of McBurney's court. I just cannot. It clips so badly. It's like driving a nail into my ear. That's what it is. And I love Judge McBurney. I just want to break the volume knob on the gain. Red Pen, you thought I was not going to do any KR coverage? No, we're not going to necessarily cover the entire trial. I'm interested in what's happening in court. I'm not interested in the drama outside of it. So I'm trying to find the happy balance. And since we did follow the original one, the happenings in today, especially with right now, I think they're in federal court making an argument for double jeopardy. Not sure when we're going to answer on the federal court, answer that one. Usually they just argue it and then leave, and then you get a written thing later. But today there's going to be the spicy arguments about getting the case dismissed for late disclosure and everything else. And I think it's going to be pretty fun to listen to that this morning. New Bunk Foss, member for 21 months. OG. Good morning, RA. Thank you, New Bunk Foss. Appreciate it. Let's see. Sending massive hugs to you, Selena. Sorry you had a bad night. I'm sorry, Selena. I know you're not doing well. Hopefully that gets feeling better here very soon. All right. Like won't get bounced at this point. I wish it would. Invested. Don't think she's going to dismiss it. Yesterday's hearing was epic and way too much fun. The good lawyering. This is what I like about it. These are next level lawyers on both sides. I know it's fun to hate one side or the other, but they're both really good, top of their game lawyers, making strong arguments for their side. At least the strongest argument that they're able to. Let's see. Storms came through upstate last night, down in South Carolina. Swing in my direction next. High winds for sure. I'm always nervous because I have a massive, massive pecan tree. Not pecan, or not pecan. I call it pecan. It's like somewhere in the middle. And those trees are known for just shedding branches, like entire limbs. You know, 1 foot in diameter limbs, just because they want to. So, pecan. Can't even spell his name right on emotion. Not the best lawyer. Yep. His spell check's important. You say it correctly. One of the few things I say correctly. All right, we have a couple things. I know Judge Simpson is doing his Judge Simpson-y things this morning. He's currently on a break. I can see that right now. So there he is. Who triggered? Hang on. My face goes away every time I switch. I have to fix this. So what's happened is my upstream keyer is it? My upstream keyer is having trouble. Let's try this again. I might have to reboot my switcher at some point today. Just every time I switch to a different camera angle, like this one, my face disappears, and that's not what I'm looking for. I don't want that. That's called tying the key for the next transition. And now is it? Oh, let's try this. Nope, still switches. Weird. Okay. One more thing I have to fix in the studio. Corey Richards' trial is starting next month. Selena, yes, it is. Out there in Utah. It's going to be exciting. Kenny Peterson, good morning. Thanks for what you do. Kenny, thank you. 17 months, Kenny. Thanks for the kind words. Appreciate you. It's called Magic. Bite Me gifted a membership. Congratulations to AEIO Mom. AEIO Mom. There's no U, but AEIO. The other vowels, sometimes Y. Recovery Addict, thanks for babysitting my dogs while I'm at work. I leave the TV on so they can watch and listen on my phone when I can. They've been liking the stream religiously, KRH. I'm not sure how you train them to do that, but I appreciate you doing that. Let's see, Virginia says I got 2 membership gifts yesterday on channels I wasn't even on. It's amazing how that works. Waiting for the judge to come back. I don't know where this lady in blue is, but I think she's in a Minecraft dungeon. I only say that because she has like torches on the wall, like flames, I think. Do you think she's in a dungeon? Okay, I think I fixed it. Just 1 second. So now if we go to 1, cut. Nope, it's gone. Oh, that's weird. Okay, I fixed it for those that are curious now, but my switcher on my computer is not doing the same thing that the switcher on the screen is doing. So, all right, it's working. We fixed it. So where are we going first? We have exactly an hour and 52 minutes before we go to Karen Reed's trial. So let's do a quick little jaunt around the true crime world and look and see if we have anything else that needs to be brought up or talked about. Let's see. Oral arguments there. Arraignments. So then my stream is full of Billy Strings songs. There's Judge Simpson. Karen Reed is upcoming. It's a quiet morning in court. Let's see if Judge Middleton has anything going on. Haven't been to his place in quite a while. Nope. He just finished about an hour ago with some arraignments. It's quiet, guys. It's quiet. What do we do during this break? Probable cause hearing for Edward Espinoza. It's in Atlanta. Let's go to Butler County.
Thank you very much.
Thank you. We'll see you at 1:30 today.
Gracias. Nos vemos a las 1:30 hoy.
Gracias.
Thank you.
I didn't understand. Please try again.
Mr. Interpreter, could you please check and see if anyone else needs an assistance before you?
Was the interpreter using Google Translate?
¿Alguien más necesita ayuda en español?
Yo.
Myself.
What is your name, please?
¿Cuál es su nombre, por favor?
José Luis Castro Rojas.
José Luis
thank you very
Castro
much.
Rojas.
Yes.
And Jen, you were trying to communicate something to me there?
Yes, unfortunately, I do not have those codes real handy. If the interpreter could call the district court, he could get those codes.
That's a beard. That is great.
You're wanting the interpreter call the district court?
Whoever is needing the Zoom code.
Okay, so the gentleman we just let go will need to call. I told him to call, so hopefully he will do so.
Okay, thank you.
You're welcome. Let's see.
Judge,
Yes.
I have one that needs an interpreter.
All right, hold on to him and I will call Mr. Castro Rojas. We are on the record in 2024 TR 3149, State of Kansas versus Jose Luis Castro Rojas.
Dígale que se espere. Vamos a trabajar con el siguiente caso. El señor Castro Rojas, estamos en el caso 2024 TR 3149, el estado de Kansas versus José Luis Castro Rojas.
Okay.
According to Woo,
County Attorney
thank you.
Darren Deviney appears for the state and the defendant appears in person and pro se.
Entonces, el señor Darren Deviney representa al estado y entonces el acusado se presenta en persona. ¿Sí?
I swear he's using the Translate app.
Would you be able to reappear at our interpreter docket today at 1:30?
Señor Castro, usted puede venir en persona a nuestra cabina de intérprete a las 1:30 de la tarde del día de hoy.
¿En persona o en línea como ahorita en Zoom?
You mean in person or do you
No.
mean online in Zoom?
It would be by Zoom again, but we would have a docket dedicated exclusively to interpreters, and we would have an attorney available if needed.
Eso sería a través de Zoom, pero nosotros tendríamos un canal dedicado solamente a los que son con intérprete, y entonces tendrá un abogado si es necesario.
It just looked like he was
And I
reading
should
off his
qualify
screen
that we would have a
when he was
defense
saying
attorney in
he was
addition
doing the
to
translation.
prosecuting attorney.
Y entonces también quiero indicar que tenemos un abogado defensor aparte del fiscal.
Okay.
You can contact our clerk of the district court to get the codes for that hearing, as they will be different.
Y usted puede contactar a la secretaria de la Corte del Distrito para que le dé los códigos de la audiencia, ya que estos serán diferentes.
Okay.
It's coming. It's going to be
Thank you,
August,
sir.
I
We'll
believe.
see you by Zoom at 1:30 today.
Gracias, señor. Nos vemos hoy a las 1:30 por Zoom.
Okay, gracias.
Okay, thank you.
You're welcome.
No hay de qué.
We
All
might.
right, Deputy, who do you have?
Let me try Judge
Okay.
McBurney's. Hang on one
First name,
second.
Francis.
Let's go to Judge McBurney. A couple of you guys are saying it's well worth the watch. I just know that it pains me to watch to listen to his court. Judge McBurney. Okay, it was yesterday at 1:46-ish. Let's try this. He speaks it. Okay, his microphone sounds like this all the time. That's why it pains me. See, everyone's just winced. It's like my ears. That's how I hear him.
Good afternoon, Mr. Pierce.
See? Did I not call it?
How are you?
Fine.
Good. I'm hanging in there. It's been a long day, but I'm sure it's been a long day for you as well. Whoop. Let's get your stuff all situated.
Y'all sit down, man. Y'all sit down.
Okay, well, you've waved to him, but this isn't a place where we have that kind of conversation. You bet. Mr. Pierce, when we were last together, we had a conversation about representation, and you told me that you wanted to represent yourself. You didn't want a lawyer appointed, and you weren't going to be hiring a lawyer. And I said, we can have that conversation. That's an extended conversation, judge and defendant. And I'm ready to do that so that we can move your case forward. Otherwise, you're kind of stuck until we clear that hurdle. You have a right to represent yourself, but I need to make sure that you are knowingly invoking that right and intelligently, which is not me telling you you're not intelligent. I just need to make sure you understand the consequences of self-representation. So that's what I was hoping we could get through today. But I always want to start by saying what is on your agenda so we can see if there's anything else.
I'm American State National, and I can't be represented by no attorney. But I have a lot of issues with me being a national that I want to address. You said you were going to let me hear me. You're going to let me
speak,
address all my issues last time I was here about me being.
Well, I did say that, but I said if you're going to address issues, I need to make sure you're representing yourself. Okay, but if we're going to do that, we have to have my conversation first. I'm required by law and by the Constitution to go through a few things to make sure it's appropriate for you to represent yourself. So you can want to do it, but I got to make sure it's appropriate to let you do it. I'll just give you an example. Let's say that you were deaf. That might make self-representation kind of complicated. You're not deaf, and so you can hear me and I can hear you, but I need to ask you a bunch of questions about your background and make sure you understand the consequences of being your own lawyer. If you assure me that you got it and getting all those things you want to represent yourself, I have to give you that right, and I will, and then you can share with me what your issues are, okay? You ready to work it that way?
Yes, sir.
Excellent.
Sometimes I
Let
wish I was
me
deaf.
get one thing here and we can get started.
He sounds great there. Back away from the mic. It's wonderful.
All right. Mr. Pierce, please tell me how old you are.
41 years old.
How far did you go in school?
11th grade.
All right. Did you ever get your GED?
Yes, sir.
When did you get your GED?
2017.
Excellent. Are you able to read English?
Yes, sir.
I know you can write in English because I got these and you actually mailed me something that
Yeah, I wrote you a letter.
about 200 pages long. All right, so you can read and write and you can speak English. Have you ever worked before?
Yes, I had several jobs.
Tell me what kind of work you've done before.
I worked for Dollar Tree when I got arrested. I worked there for Airmark. I worked there for the Move Theater in North Carolina. I had my own landscaping business. I had my own record label.
He's a
I worked
rapper.
at McDonald's, Burger King.
You've had a bunch of jobs. Got it. All right, that's helpful to know. I
McDonald's,
appreciate you
Burger
sharing
King,
that.
Dollar Store,
have
record
you
label,
gone to law
landscaping.
school?
I haven't gone to law school, but I have practiced, not practiced, I've been studying law.
You've been studying the law. Tell me how you've studied that.
Just reading, researching different case laws, sending out different statutes and codes and things of that nature.
Sure. Has all of your legal study been while you've been in jail, or have you also done legal study when you were out?
Both in and out.
Okay, got it. Have you ever watched an entire criminal trial before, start to finish?
I done been to trial before.
So you've watched one then?
Yes.
Okay. What was that trial about?
Armed robbery. The 10 years I just did for armed robbery.
So you were charged with armed robbery,
Yeah.
and that case went to trial.
Yes, sir.
So you were there from jury selection all the way through verdict.
To closing argument. I stopped before closing arguments and took 10 years.
Oh, you pled guilty.
Yeah, I
Got it.
tried right before they were finna come out for closing argument.
So you've seen 95% of a trial.
Yes, sir.
All right. You ever watched a trial on TV?
Yes, sir.
What kind of trial?
Perry Mason.
What that movie that's so called? Law and Order.
Okay, you've seen that kind of stuff. So you've seen the made-for-TV stuff.
Right.
But you've been in a real one. You were a participant in a real trial.
Yes, sir.
How long ago was that trial?
2016.
Where?
Here.
Fulton County.
Yes, sir.
Who was your lawyer?
Kevin Farm. He's a judge now.
He is. That's a small world.
Yeah.
All right. Have you ever represented yourself in a criminal or a civil case before?
No, I haven't.
This would be your first time.
Yes, sir.
Got it. Have you ever gone to a doctor or a counselor to get treatment for any mental health issue?
No, sir.
Depression or bipolar or anything?
No, sir.
Okay. Tell me why you think you would do a better job representing yourself than a trained lawyer who went to law school and has done trials before would do.
Because by me being a Mr. National, a lawyer only subject me to the jurisdiction.
So hold on 1 second. Yeah, you got it. So the court reporter needs to be able to take down what you're saying. What you're saying is important. So just don't rattle the change, and then she'll be better able to hear you. So you were telling me by being an American
State national, by me being a national, I can't be represented by an attorney because attorney automatically subject me to the court's jurisdiction.
Okay. So my question was a little different. I hear you. But my question is, why do you think you would do a better job than a lawyer? It sounds like you may think a lawyer would do a better job, but you don't want a lawyer because you're worried that would subject you to the jurisdiction of this court.
I know for a fact it'll subject me to because a lawyer is as an officer of the court, and by them being an officer of the court, it automatically subject me to the court's jurisdiction.
Okay. Well, indulge me for a minute and assume, you may think I'm wrong, but assume that I've decided that you are subject to the jurisdiction of the court. And you say, Judge, you're wrong. Okay. But I get to make the decision initially. And then you go to the Court of Appeals and they'll say McBurney was right, McBurney was wrong. But if I've decided that this court has jurisdiction over you and this case and your co-defendant, do you want me to appoint you a lawyer because you're stuck here anyway? Or you still want to represent yourself?
I still want to represent myself because I'm not under the court jurisdiction.
No chains.
Okay, my bad. My apologies. I'm not under the court jurisdiction, and I've been studying it long enough. Almost my whole family is nationals, and we know pretty much a lot about it. And we know for a fact the only way I could be subjected to a court jurisdiction is through a lawyer, because the birth certificate is a void contract, and through that contract, the birth certificate contract is what makes me subjected to the court jurisdiction.
Okay. I'm going to stop you again, not because I'm disagreeing with you. I am disagreeing with you, but we don't need to resolve that right now. I want to keep going with the discussion about representation. Before I get to the next question about the consequences of self-representation, if we fast forward and play this out, eventually you are either going to be pleading guilty in this case or you're going to trial. You're going to disagree about jurisdiction. I'm going to be very respectful and say, you know what? I hear you, Mr. Pierce, and you don't think I have jurisdiction or this court has jurisdiction over you. And I may be wrong about that, but we're still moving forward. Here comes a jury. We're going to do the trial. And so we'll go through that whole process. And I may be told I'm wrong by the Supreme Court, and then I'll have to fix that, and I will fix it. But there'll be this trial. You're going to want to represent yourself, even though we're going forward with it.
Yes.
Okay. Do you know what you're charged with in the indictment?
No, I haven't had. I know what I'm charged, but I haven't had nobody come talk to me about nothing. I don't know what's going on. I don't know.
Well, that's because you said you don't want a lawyer. And so this is what we're getting into. No one's going to come talk to you about what's going on. I'll make sure you get the discovery, the paperwork in the case.
And when would I?
It's complicated. We can get you the paper stuff pretty soon. Okay. But if I'm making this up, I don't know what's in the case. But if there's video, let's say there's surveillance video, I can't give you that at the jail. It's on a disc. What are you going to do with a disc? At the jail, you can't watch that. You don't have a way to watch that.
I mean, I would be signing a private investigator too, right? By me representing myself.
Nope, you don't get an investigator.
How do I do my investigations and this part of the process?
Well, we're going to talk about that, but you don't. I mean, that's a reason to say, you know what? I will take a lawyer because that lawyer will have an investigator, and that investigator.
But can I hire my own private investigator?
Oh, with your money, if you got money for it, you can hire anyone you want. But I won't be providing you money to go hire an investigator because you're saying I'm handling it myself. I got this. Mr. Pierce has it, which means your family would be, they could be helping you or an investigator or something like that. Or there may be some way, and I can't teach you how to do it, where you could petition to get funds for an investigator. But that's not for today. One of the consequences of representing yourself is there isn't someone who comes and sits down with you and say, let's look at this discovery. Man, the way the police handled that looks like that's a problem to me. I've been a lawyer for 20 years. I've never seen a police officer do that. That's something a lawyer could tell you after he or she reviewed all the discovery. And you won't get you're not a dummy. You could look at it and say, hey, this looks suspect. But you'd be making that decision without a lawyer helping you think about it if you represent yourself. Do you understand that?
Yes, sir.
Okay. But you seem concerned that someone hasn't already come to the jail to talk to you about what's in the indictment.
I'm not concerned. I wasn't informed on it. I know I was supposed to get a discovery package at least, or
not yet.
Report an indictment or something.
You will get it if in the end you convince me that I should let you represent yourself. Then you will get all that stuff. But no one should have given you anything yet because we're on hold. Is he going to have a lawyer? Then we give the discovery to the lawyer who works with you on that, or is he representing himself? Then we give the discovery to Mr. Pierce. And right now you're saying, I want to represent myself, and if we get through this conversation, then you'll start getting discovery. Let me tell you what you're charged with in the indictment. Count 1 charges you with murder, and it alleges that you and Mr. Baker shot and killed Samuel Curtis Harris Jr. That's count 1. Counts 2, 3, 4, 5, and 6 are all, and 7 and 8 are all what we call felony murder, which is you and Mr. Baker caused the death of Mr. Harris by being involved in a different crime: attempted robbery, armed robbery, aggravated assault, being a convicted felon, and having a firearm. Although that's just Brandon Baker. Brandon Baker apparently was a convicted felon at the time of this murder, and the murder was in February of last year. Oh, you are too. There you are. So you had a felony conviction as well. You and Mr. Baker are charged with attempted robbery. And the allegation is, and again, these are just allegations. It's not proof of anything, but it's letting you know what you're charged with and what you'll need to defend against.
Okay.
But the attempted robbery allegation is that in February of 2024, you and Mr. Baker approached Samuel Curtis Harris Jr. on foot on Mitchell Street, right near here, with the intent to take his property. Count 10 charges you and Mr. Baker with armed robbery, saying, in fact, by using a gun, you took his property. In fact, what you took from him was a firearm. Count 11 charges you both with aggravated assault for shooting Mr. Harris. 12 is possessing a gun in connection with these crimes that I talked about. Same with 13.
Man.
14 is just Mr. Baker. 15 is you. And it says that on that date, you had a firearm, but you were a convicted felon because back in 2010, you got convicted of something in Clayton County. And also, you got convicted of something here in Fulton County in 2016. I guess that's your robbery you were talking about.
Yeah.
So the thrust of it is, the allegation is you and Mr. Baker robbed Mr. Harris and shot him, and he died as a result of that. That's what you're charged with. Today is not the day to say, I didn't do it, it was self-defense, I wasn't there. That's your defense for another time. That's what you're charged with. So.
How many charges I have now?
Pardon me?
How many counts I have now?
It is.
Because I came here having 6 charges.
It's about 12 charges, but a lot of them overlap. 1 count of murder, several felony murder counts, because each of those other things I mentioned, the attempted robbery, the armed robbery, the aggravated assault, that creates a felony murder count. And then you've got a couple charges, all for possessing the same gun, but because of your criminal history, it can be charged in different ways.
But they got me charged with 3 different possession charges?
1 for possession of a firearm during the commission of a felony, and then 2 possession of a firearm by convicted felon, because you have a serious violent felony, your armed robbery, that leads to 1 type of possession charge, and the other, you've got this escape conviction out of Clayton, and that supports a different type of charge for possession.
And what that charge is?
It's possession of a firearm by a convicted felon, but it's a different type of convicted felon.
I got 2 possession of a firearm.
You do? Yep. And those may not be good charges. I don't know. That's what you would talk to your lawyer about, or that you'd research on your own if you're representing yourself.
All right.
All right. Do you understand what the penalties are for these charges?
Georgia.
Yes.
You understand that for this murder charge, you could be sentenced all the way up to life without parole, meaning you would die in prison.
Yes.
Same with all the felony murders.
Yes.
You understand that they'd all merge. You can't get more than 1 life sentence for the murders.
Say it again?
You cannot get more than 1 life sentence for the murders. You understand that? Mm-hmm. They'd all merge together.
You only have 1 life.
But depending on how the case played out, armed robbery also, you could be sentenced up to life in prison. You understand that?
Right.
Okay. And then the other offenses, they're lower sentences, but still serious. But the big one is murder with the possibility, not the guarantee, but the possibility of life or life without parole. You understand that?
Yes.
Okay. Are you a U.S. citizen?
Yes.
Do you understand that if
I'm not a United States citizen?
Well, I'm not trying to trick you. Were you born in the United States?
I'm not a United States citizen. I'm a American State national.
Okay. Tell me where you were born.
I was born at Grady Hospital.
All right, a Grady baby. That's all I need to know. There are a bunch of questions I can skip if you were born at Grady Hospital.
I'm not
if I decide that it is appropriate for you to represent yourself, do you understand that you don't get to change your mind partway through the trial?
What you mean?
Well, here's an example. In your armed robbery trial, you were able towards the very end to say, you know what, I want to plead guilty. I want to switch it up. I'm going to plead. Let's take this away from the jury. If you go to trial as your own lawyer and we get partway through and you realize, dang, this is harder than I thought. I don't really know what I'm doing. You don't get a call, a timeout, and say, Judge, find me a lawyer.
Oh, yeah.
If we start representing yourself, we finish representing yourself. Start to finish. You understand?
Okay, so if I represent myself, later on down, I can't have my family hire me a lawyer.
That's different. That's different. I wouldn't appoint a lawyer. You could bring in a hired lawyer whenever you want, knowing that if we're in the middle of trial, you could bring someone in, but we're not going to pause the trial. That person would have to jump down next to you and say, I'm ready to go. That person couldn't say, well, I need a week to get ready. But you'd be telling a lawyer, this is a strange assignment. You're going to come represent Mr. Pierce, and he's actually on day 2 of the trial. But some lawyers might be willing to do that. So yes, your family could hire a lawyer tomorrow, next month, next week, next year. Hopefully we'll be done with your case before then. But what you could not do in the middle of trial is say, Judge, I quit. You need to go get me a lawyer. Understand? Okay. Do you understand that in almost every instance, self-representation, you being your own lawyer, is a bad idea?
That's personal opinion, right?
It is a personal opinion. I'm giving you my opinion. I think it's a bad idea.
Why?
Well, I'm about to get to that. Do you understand that if you represent yourself, you are not entitled to any special treatment? There's not a Mr. Pierce rule like, hey, he doesn't know this rule. I'm not going to apply the hearsay rules to him because he doesn't know what hearsay is. Do you understand that? Whatever rules apply to the state,
he doesn't
and
know
if you had a lawyer, your lawyer, they're going to be the same rules for you.
Understood.
So if you are asking questions of a witness and you really, really, really want to get this exhibit in, Judge, I need to let the jury see this. If you don't know what questions you're supposed to ask to get it in, I don't say, psst, ask these 3 questions. You got to figure it out on your own. And if you can't, then this doesn't come in as evidence. You understand that?
I thought you were supposed to admit the evidence before you start trial.
Nope.
Well, sometimes it works that way. Sometimes it doesn't. It can work that way, but sometimes in the middle of trial, like, hey, you know what? I want to admit this now. But you don't get to ask me questions about how do I do this thing.
Oh, yeah,
if there's an objection and I sustain it, and you look kind of confused, you're just going to stay confused. I don't take a time out, have the jury leave the room and say, here are the 3 things you need to do to get this piece of evidence in. You understand that?
Yes.
That's one of the reasons why I think it's a bad idea, because I know you're smart and I know you've been doing some legal research, but I also know that you're not a trial lawyer. And so you might not know how to get something into evidence because you don't know which questions to ask. But you're aware of that. You know that's the rules. Do you understand, Mr. Pierce, that by choosing to represent yourself, you may miss possible defenses, legal arguments that a lawyer could make on your behalf to try to convince the jury to find you not guilty? Understand that?
Yes.
Yes? Okay. Do you understand that anytime that you fail to make what would be a valid objection, let's say the prosecutor is asking a leading question, and if you objected, I'd sustain it. If you fail to object, that evidence is coming in, and you don't get on appeal, say, wait, that evidence came in. Because if someone doesn't object, that's not anything that can ever be appealed. Do you understand that?
Yeah.
Okay. Do you understand that I will not be making objections on your behalf? I may be thinking, this prosecutor is breaking every rule in the book with these questions, but they're rules of evidence. And it's not my job to hit the buzzer and say, that's not a fair question. It's your job to hit the buzzer and say, I object. You understand that?
Yes, sir.
And I won't give you a little signal like a wink saying, hey, now's the time to object. You're on your own, sink or swim. You understand that?
Understood.
Okay. Do you understand that unless you take the stand and testify, none of the words that you say to the jury will be evidence in the case?
What you mean?
So lawyers are, you saw your trial. You said, hey, it ended before closings. That means you saw openings, opening statements. Then when the prosecutor got up and said, Pierce is a bad man, he did an armed robbery, you'll hear the evidence, and he held a gun to someone, whatever they thought the evidence would be. None of that is evidence. All of that is the lawyer talking, saying, here's what you may hear. You'd be free to give an opening too. And your opening might be, I wasn't there. It was all Mr. Baker. You're going to hear evidence that I was in Louisiana when this crime happened. That's not evidence that you were in Louisiana. That's just you talking to the jury. And I'll be telling the jury that nothing that you say when you're giving your opening or that the prosecutor says while she's giving her opening is evidence. It's just some guidelines that the jurors could choose to follow as they're thinking about what the case is about. The only way you would get evidence in is if you choose to testify or if you figure out how to admit exhibits.
Question.
Yeah.
What's the difference from me starting an open argument and a lawyer starting an open argument? It'll be admitted evidence if a lawyer start an open argument.
It's not. Nope. I tell the jury before we start the trial that you're going to hear from, if you represent yourself, I won't say the lawyer, I'll say you'll hear from both sides. You're going to hear from both sides an opening statement. That's not evidence. It is a preview of what each side thinks the case is about, but it's not evidence. And you didn't get to hear this because you pled out before then, but I would say, as would any judge before closing arguments, you're about to hear closing arguments. These are not evidence. These are arguments from both sides saying, here's what the evidence showed, or here's what the evidence failed to show. Evidence only comes in through someone who's under oath on the witness stand or when an exhibit is admitted, which means if you wanted to testify to get evidence in, you'd need to take the stand. And the reason for that is that's because the state gets a chance to ask you questions too. Right. Otherwise, you could just get up and give an opening saying, I didn't do it, or it was self-defense, all that kind of stuff. And you can say those things in your opening, but it's not evidence. And I'll tell the jury that. And so if you chose not to testify in your trial and you didn't put up any other evidence, then the jury wouldn't be considering what you said in your opening or your closing. You understand that?
Yeah.
Okay. Do you understand that even though you know some of the law around criminal cases and this and that, if you choose not to have an attorney, you are losing the value of an independent perspective on this case, someone who is not connected to what happened or didn't happen in this case.
What do you mean by that?
One value of an attorney is that that person comes in and looks at the discovery and says, hey, I'm coming in from the outside. I wasn't there. I don't know you. I don't know Mr. Baker. I'm telling you right now, this looks real bad. There's surveillance footage and you're wearing a t-shirt that says Ricky Pierce and your fingerprints are on the gun and your DNA is at the scene. I'm making this up, but a lawyer could say all this and say, look, Pierce, you need to work this case out because the prosecution is going to run the bus over you and back it up and run it over you again with all this evidence. That's a lawyer having a hard conversation with you, if that's what the evidence was. But you also might have a good lawyer look at it and say, they have nothing on you. You were merely present. Baker had the gun. The video footage shows Baker shooting the guy, and you're standing there looking as scared as the poor guy who got shot. I don't know what the evidence is. I do know that having your own lawyer means someone who is independent, who isn't running the risk of going to prison, can look at this and say, this is a good case for you, or this is not a good case. You will never get that independent assessment of the strength and weakness of the state's case if you represent yourself.
Right.
You understand that?
Yes, sir.
Okay. Do you understand that the prosecution will be free to bring in the most experienced attorney it wants? I won't say, hey, Pierce isn't a lawyer, so you need to bring in a brand new prosecutor who's never tried a case before, so it's more even. Understand that?
Yes.
They could bring in the big guns, and that's your problem and not anyone else's. Understand?
Yeah.
Okay. Do you understand that I will not ever tell the prosecution to go easier on you as the opposing side because you're not a lawyer?
Yep.
I'll expect them to treat you as respectfully as they do defense attorneys because you ought to be. You're the other side, but they aren't going to need to pull punches with objections or anything like that. If they think something wrong has happened, they're free to object. You understand?
Yes.
Okay. Do you understand that if you are found guilty at trial, you will not be able to argue on appeal that you were a bad lawyer for yourself?
Understood.
Because that's a claim that a defendant can always make if he's got a lawyer. It's called ineffective assistance. See, you know stuff, but you cannot say I was ineffective, meaning Ricky Pierce was ineffective.
Right.
You may have been very ineffective, but you don't get to argue that if you're your own lawyer.
Understood.
All right, you're understanding all the stuff you need to. Do you understand that you will not get extra time to prepare for trial just because you're representing you're going to have plenty of time. Trial's not tomorrow. But if you say, you know what, I need a year to get this done, I'm going to say, no, you don't. You're not going to get any more time than I would give the lawyer that I would appoint to represent you. Or if you hired a lawyer, I wouldn't give that lawyer a year to get ready. There's a family that's grieving because of a loss. You're sitting stuck in jail. And so we need to move this case along. I'm not going to rush it, but I'm not going to go slowly just because you represent yourself.
Understood.
All right. Do you understand, and this is something we've already talked about, but it's important we cover it again, your ability to investigate this case and do legal research will be very limited by the fact that you're choosing to represent yourself and you're stuck in jail.
Yeah.
You got that? You appreciate that's a disadvantage.
Yeah.
But it's a disadvantage you're willing to eat.
Yes.
Okay. All right. You understand if you had a lawyer, you hired one or I appointed one, that lawyer would not be stuck in jail with you. That lawyer would be able to go out and you could say, hey, you need to go interview Fred Smith. And they try to find Fred Smith. And they'd have an investigator who could try to find Fred Smith. You understand that?
Yes.
You're going to need to figure out how to do that on your own. Right? Okay. Now, if you had a lawyer, you understand that that lawyer could give the opening statement for you, could do the jury, we call it voir dire, but questioning jurors in advance when you're doing jury selection, could interview witnesses, subpoena witnesses, prepare jury charges, do closing arguments, cross-examine the state's witnesses. A lawyer would, should, and could do that for you if you had a lawyer. You understand that?
Yes.
And you won't have any of that if you represent yourself.
Yes.
All right. Has anyone threatened you to get you to waive your right to a lawyer?
No.
Has anyone promised you something to get you to waive your right to a lawyer?
No.
Mr. Pierce, do you want to represent yourself, at least for now, in this case, understanding that the only way you can undo that is by saying, I hired someone. Here's this lawyer for me, because otherwise you're telling me, no, I got this. You understand that?
Yes.
And do you want to represent yourself?
Yes.
Okay. Well, I find, and I'll get this in writing and enter an order to that effect in the docket, that you're aware of the charges against you, murder, felony murder, aggravated assault, armed robbery, etc. The consequences you face if you're found guilty, up to life without parole. The advantages of having a lawyer, outside investigation, independent opinion, legal expertise, etc. The disadvantages of having no lawyer, hard to investigate, hard to do legal research. But I find that despite all those things, you have made a knowing, intelligent, as in you get it, and voluntary, no one's forcing you, waiver of your right to counsel, and you are exercising your right to represent yourself, and I'll grant you that right. Any questions about any of that?
No, sir.
Okay.
It's right, but it's wrong.
So two things. One, I'll make sure that, Mr. Abate, is this your case? Okay, that's your prosecutor. I'll make sure Mr. Abate gets to me as much paper discovery as they've got. Again, there's often lots of digital discovery, and I'm making this up. I don't know what's in the case, but let's say your cell phone was seized. They might have done a cell phone dump, and there's a big old file that lists all the pictures and texts, and sometimes, maybe not in this case, after something happens, Baker texts to Pierce, I can't believe we shot that guy. And Pierce says to Baker, hey, we need to not talk about this anymore. I heard the dude died. That's great evidence for the state, but that's digital evidence. And so that might not be something that can be handed to you to look at in
How
jail.
would I access?
So what you'll get is all the paper discovery as well as a list of what is the digital discovery, body cam footage, surveillance footage. And then you would let me know. We'll have a status conference so I can see how things are going. Hey, Judge, there's some things I need to watch. And we would set up a time when you could be here and there'd be a laptop and that stuff would be there and you could watch it and take notes, whatever you need to do. It's not convenient for you, but that's how it works when you are representing yourself and you're stuck in jail. So my answer is not you can never see it until trial. It's just we have to develop a little bit of a workaround. And so you'd be watching it here. You can't just watch it anytime you want. We'll set up a specific time and that's how you digest it. Okay? I'm not saying there's any digital discovery, but if there is, that's how we do it. So I'll get from the state the discovery. We'll figure out how to get it to you. Either we'll bring you over here and hand it to you. That's often my preference because it's on the record. I see you getting the discovery, or through the sheriff's office, we'll get it to you. Are you at Rice Street?
Yes.
Okay, we'll get it to you at Rice Street. Mr. Abate, what would you say the ratio is in this case of paper discovery to digital discovery?
A lot of digital discovery. There's
Okay.
like Mr. Baker's cell phone extraction. And there's a lot of video surveillance, some of which this defendant, Mr. Pierce, is seen in high definition video shooting the victim in the head.
Okay, so there are things he'll need to see. Okay. When you generate the paper discovery, would you please include, you don't need to list the description of each video, but 9 surveillance videos,
They
2
got it
body
in
cams,
4K.
whatever the generic count is. So Mr. Pierce knows, and then he can be keeping track. Wait a minute, I've only seen 1 body cam and it says there are 2. We can sort that out.
Hasn't started
Thank you.
yet.
So you'll get the paper discovery, and then clearly we're going to need to figure out a time when you can come here and watch it. You get to watch it privately. The prosecutor's not going to be there while you're doing it because you may have a reaction to it, and take notes, whatever you need to do. That's number 1. Number 2, are there things that you think we need to talk about now, or now that you represent yourself, are there instead things that you want to get in writing and file as motions?
Yes, I have 2 motions that I want to file. I have them wrote up now in my thing, and there's a lot of issues that I have to address as far as with me being a national, just putting it on a record for my benefits.
Okay, so let's do that. Let's do 2 things. 1, I want you to put on the record, we want to just do it. You're free every time we're in court together to remind me that you're American State National and you don't think that there's jurisdiction. But what I would ask you to do, you're going to share, it sounds like a fair amount right now, to get it on the record. We only need it on the record once because you will have made that record. And then in the future, all you need to do is say, hey, I rely on the record I made. You don't even need to state the date, but that I made before about my objection to jurisdiction or whatever you want to call what you're about to share. So I'll always let you make a record, but I will push back a little bit if next time I see you, like, hey, I need to make that same record again. No, you don't. You made it, and you only need to make it once. And then there's a transcript so that if you need to take something up on appeal, they only need to read it once. All right?
Would I get transcript from every court proceeding? Or how do that work? Do I have to file for it?
So
or automatically get it to me? I'm representing myself.
So every time Ms. Rivers is taking something down, we can create a transcript. We don't immediately generate transcripts because, for example, if you go to trial and you're found not guilty, we don't need to create a transcript of any of that because you're done. You go home. If you're found guilty, then we need to make transcripts of everything because all that goes to the Supreme Court for the appeal. Between now and your trial, we typically don't create transcripts unless, just as an example, let's say we had a suppression hearing and the lead detective testified and talked a lot about the work that she did on the case. Everyone wants a transcript of that because she's going to come back at trial. And if her story changes, then someone wants to say, wait a minute, you were in court 2 months ago and you said Mr. Pierce was wearing a blue shirt and now you're saying he's wearing a red shirt. Which one is it? And the jurors are wondering, why is this detective changing her story? But things we're saying today, that kind of transcript we'd make only if you're found guilty and we need to push stuff up to the Supreme Court. But it is being preserved if Ms. Rivers is here and doing what she needs to do, which she is. So why don't you briefly share with me the things you want to get on the record?
Keyword being briefly.
Your Honor, let the record reflect that I'm American State National, which is a private American. I'm here on a special appearance to administer the affairs of the All Caps Trust. I am the living man, Ricky DeMond Pierce, and not the All Caps Legal Fishing Corporation or dead entity. I stand on the land and soil jurisdiction, and that's the highest jurisdiction on the man. This is my oral request of me changing the court's jurisdiction over me here today. I have not contracted with the court in any kind of way, and I don't plan on contracting with the court in the near future. I have been forced to come here against my will and God-given rights under threats enforced by your government officials, which is kidnapping. Your courts have no jurisdiction over me, and I stand on the land and soil jurisdiction to have proof of it when I came to court on January the 30th, 2025. Your courts, plus in Louisville versus Motley, if any tribunal finds absent of proof of jurisdiction over a person and subject matter, the case must be dismissed. Your court's jurisdiction is the jurisdiction of the sea, which is the Admiralty and Maritime Laws, which is also a military tribunal, and the courts are known as a ship of war, a privateer, or a battleship. I am under public law, which is common law, which is also the law of the land, natural law, God's law. I have God-given rights that can't be violated, and the courts are under admiralty and maritime laws, which is a foreign law to sea jurisdiction. See Article 3, Section 2 of the United States Constitution. And no living people live there, only dead persons, legal fictions, corporations, and dead entities. Because our cities are considered dead entities, which is another reason why you have to dismiss this case, because the living cannot be judged by the dead. Another problem the courts have, because my God-given right says I have to be tried amongst my peers and a jury of living people, which is American state nationals, and also can't happen because our nation is not under the court's jurisdiction and will not show one order because they hold a higher jurisdiction. In the original Constitution, Section 3, Article 3, Section 2 states that the United States, the corporation judicial power is under admiralty and maritime jurisdiction. And I am under the land and soil jurisdiction, and I have gave courts proof for this when I came to court January the 30th, 2025. I also mailed off my executive letter, the notice that President Trump sent out January the 4th of this year, letting all patriots know that these laws have been dissolved due to breach of oath, due to fraud and breach of oath for office. And I also mailed off a copy of my certified mail. I mailed off certified mail and have been received. I am also requesting your oath of office, Your Honor. The notice that Trump sent out goes as follows. Notice to patriots, date January the 4th, 2025. This is to inform all patriots that effective immediately, our government and government corporations are hereby dissolved due to breach of oath. Additionally, our statutory and foreign laws are also dissolved. The only legal framework that remains in effort are constitutional law as outlined in Article 61 of the Magna Carta and established common law. This directive is especially for corporate bodies and government workers. Any government corporate body, including police, judges, lawyers, and any individuals operating in these capacities must cease operation immediately. Those who continue to operate after this notice will be liable for prosecution for fraud and breach of oath. It is imperative that all government workers comply with this directive. Failure to adhere may result in serious consequences and even including potential military actions. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, from without the United States of America, the de facto government, and without the United States of America, the corporation territories. I reject, renounce, and remove all powers of attorney granted to me or issued under my name prior to this day. My birth certificate was the only contract that subjected me to these laws, but the birth certificate contract is void because I was only a minor and had no knowledge of this contract when it was constructed, which made this contract void.
I didn't consent to my birth certificate.
Subject matter jurisdiction over me. I am no longer an employee of the government, which is the corporation government. I declare on the penalty of perjury on the public law of the capital T, United States of America, the de jure government, that I reject, renounce, and remove any and all alliance to any king or prince, any foreign state, any foreign government or flag. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself to any incorporated entity at all, including but not limited to any incorporated church, synagogue, mascot, or temple. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself of any foreign state, foreign sovereign, or separated myself from my birthright political status as American state national. I declare, publish, and affirm on the penalty of perjury on the public law of the United States of America that I am a lawful inheritor, acting with full rights and authority, responsibility, and honor now and always while my tenure on earth shall last. I, the living man, Ricky DeMond Pierce, affirm and declare that I have returned to my lawful birthright political status as a Georgian, and I have copyrighted and trademarked the all caps name, which is a trust and not the living me. I have occupied my executive office and never gave the courts any permission to use the all caps name, which is fraud.
He copyrighted his all caps name.
I have over 40 violations that the courts have committed upon me and my God-given rights as American state national. And I have counted over $800 million in violations over the time that I have been incarcerated at Fulton County Jail, these 150 plus days, and it's only adding up as I sit in Fulton County Jail against my will and consent. And they are as follows. 1. These are all combined municipal and territorial notices of violations against Americans with failure to perform any and all occurrences listed below in this section, starting at $10 million. A. Notice of claim of sole relief and remedy. B. Notice of violation of the Lanham Act, attempted attachment and seizure of unregistered trademarks, Title 15, Section 1125, 8 and 11. Notice of violation of admiralty and maritime and prior cases, Title 25, Section 1331, 1, 2, and 12. D. Notice of violation for special maritime and territorial jurisdiction of the United States, Title 18, Section 7, 1, 3, 8, and 13. E. Notice of violation of the Postal Accountability and Enhancement Act of Title 39, Sections 1-3908 and 3621-3591. F. Notice of violation of presumption of the Public Vessel Act, Title 46, U.S.C.A. Appendix, Section 781 through 790, as originally enacted. G. Notice of violation of the False Claim Act, Title 31, U.S.C.A. Sections 3729A and 7. H. Notice of violation of the Foreign Sovereign Immunity Act, Title 28, Section 1602 through 1611. I. Notice of violation of the United States Statute at Large Act, Title 12, Section 411. K. Notice of violation of the Geneva Conventions by the United States Department of Defense.
Mr. Pierce, I'm going to just pause you for 1 second. You were on K. How many letters? I want to make sure
you're
almost done, because we're getting into international stuff, and that's getting a little far afield.
2. Private easements fee schedule. Penalty for private use, $250,000. These fees will be mandated upon the informant listed on the warrant, citation tickets, arrest warrants, detention orders, and seizure orders. Compulsion to produce trade name or other identification materials. A. Name, $50,000. E. Fingerprints, $200,000. F. Photographing, $200,000.
That's what he charges for his
DNA,
fingerprints.
$5 million. Blood sample, $5 million. Personal property, trespass, carjacking, theft, interference with commercial trade. M. Color law, $150,000. N. Implied color law, $150,000. T. Fraud, $1 million. U. Fraud upon the courts, $2 million. BB. Stimulating legal process, $1 million. Use of trade name and copyrighted protected material on a threats, duress, and or coercion. Name written by a informant, $250,000. Miscellaneous material written by a informant, $500,000. Court appearance fee schedule. These fees must be paid immediately after my case is finished. Failure to pay fines and fees will result in an additional fee of $5,000 for breach of contract. Demand for appearance in court. My appearance on a protest and duress per hour, 1 hour minimum, $75,000. Use of trade name material.
How many more pages do you have?
I have quite a few.
Okay, so I'm wondering if, and I'm not going to curtail you too much, but you'll be able to file that, which will make it even more of a record if you want it to be filed, or you could give it to me and I'll file it for you. But that's up to you. What I don't want to do is I want to make sure we're moving your case forward, and
we're going backwards.
This is pretty lengthy. It might be more efficient to have it filed into the docket so that we actually see, hey, there it is in the computer system.
I really need to get it on the record, and I need to file the motion to be able to address these issues also. I have the motions already wrote. If you give me a little time, I can get through it pretty quick.
Well, I don't want you to read too fast because Ms. Rivers needs to be able to take it down. Would you say we're more than halfway through, or are we not more than halfway through?
Yeah, we're halfway through.
Exactly half or more than half?
Exactly half, because it's 20 pages. I'm on 11 now.
Okay. Well, let's go. Don't read too fast, but don't read too slowly.
Okay, hang on. We're going to pause right there. We're going to pause. I'm sorry. We have to bail on this because we're going to go over to Karen Reed and follow the hearing that happens. He's halfway through. This is the funny part. So I drew out of that. He's instigated. He's instituted his own fine and fee schedule for all the crimes that have been committed against him. Okay. And he is saying all of these are due immediately as soon as my case is finished, which it should be right now because you don't have jurisdiction over me. If you don't pay this $800 million total fine, then we're going to fine you $5,000. That's what we're going to fine you. I was like, well, I think I'm going to, how many times can I get fined $5,000 before I have to pay the $800 million? This is great. We'll have to go back and get the rest of that here in just a minute, but we've got to get ready to jump over to court where Karen Reed's expected to start here in just a minute. The judge, man, who was patient. He explained things, some of the best explanation for a pro se defendant I've ever heard from Judge McBurney. The patience of a saint, right up there with Judge Darrow. Okay, give me a second to get everything lined up. All right. Whoa. That was Judge McBurney. You know where that wouldn't stand? Who was it? The standing judge. Can't remember his name off the top of my head for some reason. Somebody type the standing judge's name so I can let my brain rest. I can't think for a minute who he is. Yeah, he would have shut that down in a heartbeat. I will, but it'll cost you $5,000 payable immediately. The Greeners, you know I'm good for it, right? You know I'm good for it. Just spot me a quick one. Judge Oakley, thank you, Melissa. And it didn't cost me $5,000, Greeners. See that? Man, wild and crazy. That is nuts. Why is that camera on? Test, 1, 2. Oh, weird. I actually had the wrong audio on. All right. We'll see if we can go back and follow the rest of that here when we get a second. But where we are in the Karen Reed trial, buffer mod chat and Facebook DMs. Mod chat. Thank you. A lot of filings here. Amber, this is a ton to read. You sent me like 15 documents.
Are we going to address subject matter jurisdiction?
We would ask as we're following the Karen Reed case. We love courts. We love courtroom drama. We don't necessarily like around the courtroom drama. So if we can keep the discussion here today as we're listening to this, sort of based on the events in court and the happenings here, let's keep the drama out. We don't need all the name calling and things like that, which really takes away from the experience and takes away from the sort of the legitimacy of watching court instead of, if I wanted to go to the circus, I would have gone to the circus, right? So, but let's just be respectful with each other. If we disagree, that's all right. We don't have to prove the other person wrong or prove ourselves right. And basically, I'm asking for you guys to be nice to our mods. That's it. Not my monkeys, not my circus. So Sharkey. I'm going to call you Sharkey today. It's not going to be Shark. The federal court for Karen Reed just finished. Judge says he'll have his decision as soon as possible, considering the situation, which is appropriate. Thank you, Sinbad, for that. The federal court that they were going to was, well, they're basically just across the street, right? Not far away. Now they're going to zip back over to Judge Cannoni's court. They were asking the federal court to weigh in on the matter of double jeopardy. basically get him to say, can we have a higher court's take on this? Was this, is this double jeopardy with her being tried again, or should have been considered a verdict from the original jury? I don't think they're going to count it as a verdict. Can we discuss your big budget Christmas lights? Here they are. That's them. Whee! I got these at Lowe's. Is that the ones you're talking about? I'm actually going to throw these ones away because I can't straighten them out. Let's see. Or are you talking about these lights? Those lights are actually... It's just a little string, a roll of LED lights that glue on the bottom side of the desk and then plug in via USB. I have a couple of those now. All right. Let's see. Amber says, please stick to the facts as presented in court and filings. We do not participate or condone any outside drama surrounding any case. Drama starters will be escorted from chat for the remainder of the day. The mods have given us a warning. We're already on our last warning. Heidi, welcome to the gallery. Thank you very much for being here. Love your support. Congratulations on that blue courthouse. That's month 2 for you. I think it's 2, possibly 3. I don't remember which one goes first, but congratulations there. Let's see, am I going to turn the Christmas lights into St. Patty's Day lights? The ones on my house, no, they're just Christmas lights. I actually need to take them down this year. They've been up for 1.5 years now. All right. Heidi, thank you. In this hearing today, I think we should count something. I think we should count police sirens and or car honks. Would that be a fair thing to count? What happened with the city going into your basement? I filed a report with the police, and it's just on record. That's about it. And I took some personal security steps that will probably seriously do bodily damage to anyone who tries to come through now. It's just booby trapped. So high explosives, things like that. Roni, I'm just kidding. Roni says, love you guys. 13 months. Congratulations. You are 1 month into your 2nd year. That is awesome. Thank you very much. I love the bat, by the way. Did he get a new Lego? Yes. Okay, I'm gonna share this one. I'm gonna share this one because I'm not sure if this is a fair set to use. So I need your. I went last night. I took my kids to the store. We went to Target and Barnes and Noble because there's no way my wife would let me take my kids to the murder Walmart. So I bought a set, and if I remember correctly, Valhalla Awaits was in our chat yesterday, and I asked him how big of a set to use, and he said 500 to 700 pieces. And so I found one with 503 pieces, and it's this garbage truck, but it's a Technic, Lego Technic. That still applies, right? It's still Lego, I think. Plus, it actually, like, you can turn the crank and the garbage can goes up and dumps. And it being garbage day today, and I was thinking about my garbage, making sure it got dumped. So technically it counts. I might not open it. I might use the one that's hiding right over there, which is a secret. But you can put the rotten meat in back for realism. I could. You could add the scent. I'm not sure if it actually, I don't think it has batteries. It says Mack Electric, but I think it's just a plastic model of a real-life electric truck. It looks to be all manually, you turn the crank and things happen. So it might be, it says ages 8 and up, so I figure it's right in my skill level. But 503 pieces should be good. Hang on, we're getting a call. Let's see if I can plug it in time.
Call from Angela.
Good morning, Angela. How are you doing this morning?
Good morning. Good. You?
I'm doing well.
Well, I'm calling to officially say it is legal.
Yes.
As someone who is neighbor with the country that invented Lego, it is legal.
Okay, so it counts.
You can find it counts. You can find Lego Technic on Lego's website, official website.
The only thing I'm concerned about is I'm familiar with Legos and how they fit together. Lego Technics are different. I don't know how they fit together because I'm not seeing any of their.
They are like for the old. Lego is usually for the kids, but Lego Technic is like for non-kids that want to be kids.
So me.
You know. Yeah.
Well,
so it's all right. You're all good.
I got that. Thank you very much. I appreciate the affirmation. I got that set because it's one that my son would like to put together in case I don't use it, because I do have another set with thousands of pieces and that I might try to build instead in 3 hours.
Let me put it this way: how Lego Technic is popular. There is this set which is, thank God, back in storage or whatever. It was last year. It was a 6 months waiting period, like waiting list. You have to wait like 6 months to get it.
That's crazy. I've seen some of the collectors Lego sets. Like there's a 100-year anniversary Walt Disney studio like film camera model. That one's like I would like something like that. I'm all about cameras. It's too expensive and too big. I would never get that one done, and it's a really difficult one. But they do come out with some.
It was like a car.
Yeah.
It was like a car. It was the Senna. My brother loves that car, and he's like, "Oh, when I grow up, I'm gonna buy the actual car." I remember what was McLaren Senna. Now I remember.
Oh, McLaren, nice car.
That was 6 months waiting period. Now it's back in stock.
Yeah.
Thank God.
Well, I looked at every single Disney, Marvel, Technic, Architect. I looked at every single set that was for sale in Target and at Barnes and Noble. I know Barnes and Noble's a bookstore, but they have a huge Lego section. I looked at every single set, and I set the minimum of 500 pieces, but I didn't want to go up to 1,000. And this was the most exciting one for me. So hopefully I can get it done in a couple hours. So.
Good luck with that. Well, back in the time now, my brother is older, so he does it himself. Every time it was his birthday party, guess what he gets for birthday?
Legos.
Lots of Legos. And guess who gets put them together? Me. So
he gets Legos and you build them?
And he plays with them afterwards.
That's funny. That's really funny. Well, that is awesome. Thank you very much. I appreciate it, Angela.
Thank you.
All right, we'll talk to you again.
Thank you. Bye-bye.
Bye. So Lego Technic still counts. So that's good. All right. I'm pretty sure nobody has done the garbage truck on Valhalla Waits stream yet. So my fear, it's not that I don't want to do something someone else has done because I want to be new and different. It's that I don't want my build of the garbage truck to be lined up time-wise to anyone else's and to be come in second place, because everyone knows it's a contest even though they say it isn't. So I just don't want to have anyone else to be up against. We need to build a Lego set for each trial. Oh my goodness. dog lover. If I had infinite money, that would be a fun thing to do, to build a Lego model for every single trial. That's crazy. Will you get all the right bricks in all the right places? Only I will know. Okay, we are waiting. I think the court for Karen Reed is delayed a little bit because of the federal court just barely ended, and now they're just coming back across the street. It'll take a minute to get started. Not sure how long, but people can solve a Rubik's Cube in under 5 seconds, so 500 Lego pieces is maybe double that. I don't know. I think the Lego sets would have to be the small ones. There's no way I could afford like a Hogwarts castle type, Hogwarts school set for each trial, but maybe a little tiny set, little car. Federal court is 30 minutes from Bev's courthouse. Oh my goodness. Do we know what time they ended? Gracefully Broken Mom, we do not know how federal court went. They're going to issue a ruling at some later date, probably in the next week or two, would be my guess, or at a bare minimum this month before the next trial begins. I think it would be a mistake to proceed with the next trial without a decision on the federal side if this is, in fact, a violation of her double jeopardy.
Call from
Master Eden.
Good morning, Master Eden. How are you doing today?
Good. I'm going to try to be really quick. Looks like we're going to have ourselves another Mr. Pritchett 2.0.
Oh,
and I'm wondering, do you think we'll be able to cover this case in its entirety?
I don't know if it's going to be televised in its entirety. It probably will. Mr. McBurney's pretty good about doing that.
I was hoping he used an example of Mr. Pritchett. Like, there's an example of another young man who did the same thing you did, and it didn't quite work out.
Yeah, you've probably bumped into him down at the jail. Here's Mr.
Probably right.
I would give him this. His argument. Maybe it's just that this judge allows him to get further in the argument than any other judge would. But it had everything.
Right.
It had all the parts and pieces. It had the Admiralty Court. It challenged his authority. It challenged the court's jurisdiction. It talked about his birth certificate, how he did not consent to a birth certificate, even though normally a birth certificate would make you subject to jurisdiction of that land, according to his logic. He had all the pieces together, which was impressive. But I do think it was probably copy and pasted from the internet.
It was. The only thing he was missing in that argument is every sovereign argues, I can't be accused without a crime. There has to be an injured party. And it's like, well, he's definitely injured. He's dead. You will be able to face your accuser because his picture will be in this case. So he kind of missed some key parts in his argument. But I like Big Birdie's style because he almost lets you bury yourself. He wants this to be an example to anybody else thinking about this. So when they see this on YouTube, they're going to say, well, maybe that's not going to work because it didn't work for that guy.
Yeah. Master Eden, I have to say, I think it was on X the other day. It was either X. Mm-hmm. It wasn't YouTube. I think it was like X or on Facebook. And I came across an ad for a guy who literally pays for advertisement to basically sell this information or, give you information about being a SovSit and how you can beat every trial. And I thought it was a joke, but there's a guy out there who's actually paying, and he's like, yeah, here's how to do it. Here's how I beat the system and how you can too. Right. And it's this. It's SovSit. And it's a paid ad. The comments are hilarious in response to it. But
there's a guy on YouTube that does it. He calls himself the Wolf, and he literally is playing a lot of people in jail.
More people are incarcerated because of him than anyone else. I mean, there's no.
I think he works for the government. Like, hey guys, I'm giving you.
Give me an easy one. It's going to be a SovSit. Lock him up.
Right.
Yeah, the wolf. That to me, let me just say, he's probably a very litigious person, is my guess.
Very.
To me, it seems like the information is the least helpful you could possibly receive if you were facing any sort of legal proceedings.
Especially a murder charge at that. Oh my Lord.
Just 12 counts, murder, firearms, all that. All the aggravating factors. Life in prison without parole in Georgia.
Right. It's Mr. Pritchett all over again. It's like, sir, these are petty charges. These are pretty serious. You may want to get a lawyer.
Yeah.
Oh Lord.
It's good stuff. Master Ayden, thank you very much. Always good to talk to you. See you, my friend.
Oh yeah, always good to hear from you. All
right. Bye-bye. All right. Do SovSits receive government assistance? No. Well, are you talking about like food stamps and Social Security, things like that? I don't know. That's different. I've never heard it. I've never heard those details. Have a great SovSit family member story. It includes a full SWAT raid and filing false liens against the Secretary of the Treasury of the U.S. to his home address. You put a lien on the Treasury of the United States? Good luck collecting that one. Here's where the SovSit argument falls apart for me. Don't you think that at some point your right to live as a free man intersects with someone else's right to live as a free man or woman? They use free man, so we're going to use that phrase. Don't you think that the person who was just walking their dog down the street, who got shot in the head and their dog and their gun stolen, don't you think that person had the same right to just live and walk down the street as you do? How can you just take that right away from somebody, that other person, and be okay with it, and then say, I'm a free man, so I get to do what I want? Do they really want a lawless society? Ivan's like, where do I sign? Don't use your pro-government logic on me, says Greenwich. Can someone tell me why you'd want to be a SovSit? I don't understand the appeal. I think it's the idea that you can get away with murder, quite literally. And usually I think people find this idea appealing after they've been charged with murder and realize that they're not going to win. The gentleman who was in Mr. McBurney's court just today, he was in yesterday, that we watched today, the prosecution has, in high definition, a video of him shooting the victim and killing him. That's some pretty compelling evidence. I think that's probably why he started looking for. And he found out today. He has not seen his discovery. He found out today that they have that in HD, and he's like, "Oh, we've got that." That's the first time he found out he did it on camera. All right. You're watching Hour of the Wrong stream. Noms. You're here now. It's good. Oh, not the Treasury. The cabinet member personally. It's the strawman theory that the government is hiding millions of dollars under our names, so it should belong to us. It's nonsense. Oh, great. Great. I think I'm all about transparency and freedom of speech, but there's a point where companies should just do the right thing and not pass on this gibberish. Graders? No. I don't think we talked politics. I think we're talking SovSit, which is a little different. Just waiting any minute now. We're supposed to be back in Canton. So we'll see. We'll see if we can get everyone, all the players in place for the big fiery argument. Getting some Lego pictures sent to me. Oh, wow. It's a Lego set of a book that opens up and the characters come alive on the page, basically. We must watch his trial. We'll watch for it. We'll watch for it. Is today something that she may give us an answer on? Probably not today, but I want to hear the arguments. It's probably going to be in the next week or so that we get an answer. Quick reminder for what's happening the rest of the week. My schedule is busy. I have tomorrow's the podcast. Friday evening, I have a private venue that I'm going to go live stream a production. It's actually, I think it's a training class or something I'm live streaming. Saturday, I'm live streaming my friend's funeral for family only. Saturday evening, we have the podcast with Valhalla Awaits. Sunday morning, I'm live streaming again for a church near me. We're trying to help them figure out a live streaming solution. So it's going to be a busy weekend. I'll be doing tech stuff all week. Sloth Life, I'm planning to go to the mailbox before, at lunch. But it's 11:30 right now. I don't know if we're going to get a lunch. The weather is going to turn nasty, like scattered tornadoes, 60-mile-an-hour winds here. So as long as the trees aren't down on the way there, it'll be good. Greeners, it does sound a little threatening. I will say I would be emotionally just a wreck at that funeral. And so luckily I'm going to be off in another room running equipment remotely. So I can just cry there and not disrupt everything else. But still don't know what happened. He just passed away at the age of 37. So just went through the Charlotte area. It was nasty, says Oatmeal. Did you guys have trees down or anything? Any branches? When do we expect a ruling in the corn rake trial? That one, Tara, is going to come in about a month from now at the soonest, because they had 30 days from the last day of trial to file their last brief. Did I miss your Lego thing? I showed the Legos I'm going to use on Saturday, but Saturday will be the live stream. I don't know. I'll have to check with Valhalla Awaits if he wants me to live stream it on my channel as well, or if I'll just be on his channel. I'm okay doing either one. Obviously, if it was on my channel as well, it would be probably easier for you to find it, but I definitely want you to follow his channel as well. So we'll periodically put the link up in chat for Valhalla Awaits, the live stream specifically that I'm going to be on. And Charlotte had to seek shelter this morning, 9 for tornado warning and watch. Nothing crazy happened. All clear now. I can hear like boards blowing down the street on my house right now. I don't know whose house it came off of, but it's already getting windy. All right. What's frustrating is we probably could have watched the entire Sov sit. A couple more updates in the world of true crime. There's one particularly that's interesting. That is the case out of Kentucky with the sheriff who shot the judge. Now announcing that they're going to file paperwork saying that Mickey Steins, the sheriff, is going to be using the insanity defense in that trial, which might explain everything. All right. Oh, this weekend as well. Daylight savings. Daylight savings. Don't forget, we lose an hour of sleep. Hate when the trash bins fly away. Camilla, this might be one time when I'm okay with it happening, because mine are terrible. They're in terrible shape. And the garbage man just came. They're empty, and now a huge windstorm. This might be the answer to all my prayers with my stinky garbage can situation. If you missed the story about the neighbor gifting us some meat and it going rotten in our garbage can, and you have to go back and listen to that one. And then it falling out in the street and the neighbor seeing it. Yeah, it was terrible. People who know the sheriff say he was acting a bit strange days before the shooting. When it's horrible. I'm hearing a train. That's the second train I've heard today in town. We normally get one a week. Yes, Virginia, this weekend, it's the spring forward side. Spring forward, fall back. So spring forward 1 hour means we lose an hour of sleep. Serious question. Do soft-sits acknowledge daylight savings time, or did they show up an hour early for all their meetings for the next 6 months? I just think they don't show up for any meetings, because who would make them? Who has that authority? Isn't it this weekend? Hang on, let me check now. When is daylight savings time?
This year, daylight saving time starts on Sunday, March 9th, 2025, and will end on Sunday, November 2nd, 2025.
There we go. So for us, it's the 9th. The clock in my car will finally be right again. Virginia, that's funny. We are just waiting. If you're hearing a train take cover, good thing you have a real train in town. Yeah, this is a train horn, not like an engine. Tornadoes, it's like toot 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 toot. It's doing the code it does when it crosses the road. Break, or are you done yet? Let me know. Ivan needs to call so court will start. Ivan sent me a picture of a video of snow yesterday. I think that was him. I have to work that night. Love working during spring forward, but not working when we fall back. You get a free hour of pay? I've never thought of that. What happens to the people who are working when the clock switches? Okay, the curtains in my room are blowing, like swaying away from over there. See how they're moving around and swaying back and forth? My windows are closed, but the wind is blowing enough that the curtains. My house is a sieve. It's like living in a giant colander, like a noodle strainer. The wind comes right through. Overnight shift at my previous place, got paid that extra hour. People working in the hospital at night get an extra hour of pay. Natalie O says, love this channel, RA, mods, and chat. Natalie, congratulations on 16 months. It wouldn't be the same without you here. Thank you very much for being a member. Monday it was 70 in Nashville. We may get snow flurries in the next 24 hours. I normally don't pay a lot of attention to the weather, being someone who works inside. I don't have a lot of driving to do. So the weather comes and goes, and it does its thing. As long as it's not severe weather, I'm fine. I have been addicted to watching the Arms Family Homestead on YouTube. And Daniel Arms on that channel, the owner of the channel, he's got this large farm that he's building a massive pond on. It was a 1 acre pond. They just completed the construction, and it's now a 4 acre pond. And he just wants it to fill up with rainfall. And so I'm watching the weather for him to see when there's going to be a ton of rain to fill up his pond. I think it will take years to fill up. He thinks it will be just one summer, but it'll be interesting. He's down there on the Texas-Oklahoma border. Ann Cloutier gifted 5 memberships. Thank you, Ann. Very generous of you. Sounds like a lake. Should watch I'm a Survivor Sanctuary. My wind chimes are working overtime. We have some wind chimes that were given to us by Diet Coke Mama when we moved out here. And I have left them up through every storm, through every hurricane, through everything. So they're going like crazy as well. I'm the only one in the whole neighborhood who has wind chimes. I hope nobody hates them. You got some orange courthouses in those gifts? That is awesome. We do everything to not have a pond on our property. I love fishing, though, so much. I would never swim in a pond. I'll swim in a lake. I won't swim in a pond. The idea of stagnant water and what grows there scares me. Mr. Bones looks like he's rattling. Yeah, that's my fault. Lady Justice is crowding the scene. Here we go. Normally my kids put Mr. Bones' arm over Lady Justice like that. They would not work hanging out the window on the 26th floor. Florida has some nice ponds. I won't swim in Florida, period. Daylight saving time. Only one saving. We can't be greedy. I say daylight savings. I put the S on the end. But only saves 1 hour, singular. Okay, I know it. You know what would bring this to a quick start in Canton? Is if we went back and watched the rest of that Sov sit. Let's see. I got sidetracked. Sorry, what am I looking for? All right, so let's do... Let's bring that one over here. What is that? Got to reboot this machine. Hang on. Restart that one. We can watch Judge Simpson while we wait in just a minute, but I've got to reboot that machine before we switch anything. We should name you Dory. Okay, input list. Input. It's already rebooted. Don't look at my password. What in the world? I'm getting a weird box that shouldn't be there on my screen. Okay, so that computer is unusable. That means I have to use a different one. All right, let's try this one. Okay. We're all set. Okay, we're going to go back and watch McBurney's court really quickly. You guys ready?
Down. Would you say we're more than halfway through, or are we not more than halfway through?
Yeah, we halfway through.
Exactly half or more than half?
Exactly half, because it's 20 pages. I'm on 11 now.
Okay. Well, let's go. Don't read too fast, but don't read too slowly.
Trespass and failure to act fee schedule. Use of trade name material, name on the protest and duress, $25,000. Miscellaneous material, $25,000. Time uses for court appearance, 30 minutes on the protest and duress, $33,500. 60 minutes on the protest and duress, $75,000. 90 minutes or more on the protest and duress, $100,000. Trespass and failure to act fee schedule. Trespass by public officials, police officers, judges, detectives, attorneys, corporations, and other fictitious entities as well as any other who desire the contract. A, trespass on American homestead land, $10 million. C, failure of attorney to file requested FARA form, $1 million. Failure to accept American State National card, $1 million. Failure to honor God-given rights, $20,000. Failure to honor oath of office, $50,000. Failure to honor constitutional oath, $50,000. Failure to honor written and oral word, $5,000. Failure to honor no bond, honor a bond/no bond, $5,000. Detention from free movement and or cuff per hour, 1 hour minimum, $75,000. Incarceration per hour, 1 hour minimum, $75,000. Failure to follow federal and or state statutes, code, rules, and regulations, $50,000. Failure to set a claim upon which relief can be granted, $25,000. Failure to present a living injured party, $100,000. Total damages for each line set forth in a above schedule will be assessed as the total amount of damages as set forth herein times 3 for a total of all damages added to a 3 times the damage for punitive and other additional damages for a total of $1,019,631,000 US dollars.
1 billion, you're at to the B.
Yes.
Okay, that's a lot of money.
And that's just for the amount for me being incarcerated these 120 plus days. Your Honor, all laws are commercial, and all laws are not laws, but codes, statutes, mandates, regulations, and all the rest. And I'm a private American are not under commercial law. What's legal aren't law, Your Honor, and what's law aren't legal. And Your Honor, ignorance to the law is no excuse, and that goes on both ends, mine and yours. This declaration is valid, true, correct, and complete in all jurisdictional law, air, land, and sea. Your Honor, let the record reflect that if you are against this, this is warring against the Constitution. And warring against the Constitution is called piercing the veil. And piercing the veil is called treason. Treason is punishable by death, and there's no remedy for treason. Also, in Orange versus Independence, also the court have no immunity from persecution when violating the constitutional right. I am honored the United States of America, the Danjur government, the Confederation of the States.
Mr. Pierce, there's one phrase you've used a whole bunch of times, and I don't understand it. The what government?
The Danjur government.
What is, spell that?
D-E-J-U-N-E, space J-U-N-E, Danjur.
D-E.
What does that mean?
J-U-R-E.
Oh, got it. Okay.
Danjur.
Yep. Thank you.
Okay, which is the Confederation of the States. And the Federation gave the United States, the corporation, the de facto government, the power to operate out the 10 square miles, which is in Washington, D.C. And any laws outside of Washington, D.C. is commercial. And private Americans are not under commercial laws. We are under public law, which is common law. My God-given rights has been violated by being forced to give my DNA, fingerprints, eye pattern, and blood DNA against my will. I never consented to them arresting me or detaining me after I put them on notice of my political status. Your Honor, United States, the de facto government, is a for-profit corporation, which means they have a Dun and Bradstreet number, and no corporation can interact with a living man under another corporation. Your Honor, it states that every man is independent of all laws except those prescribed by nature. No man or woman is bound by any institution formed by his fellow man without his consent. See case law, Cruden versus Neal, 2 N.C.338, May term 1796. Your Honor, in 1845, the then Pope and the British monarchs, both of whom were honor bound to act as trustees for United States Trust, and both of whom acted in gross breach of trust, agreed that the American experiment was not working. The whole idea of self-rule was antithetical to the idea of divine rights of a king's supremacy. So they signed a secret treaty of Verona and agreed to undermine the American government. The British Monarch Commercial Company, which controls the bankers and lawyers, issued license to lawyers to act as privateers. That's why the Bar Association requires licensing. Acronyms for bar mean British Accredited Registry. Anytime we see the word license, it means that someone in a position of rulership is giving someone else permission to do something that is otherwise illegal. In this case, the king gave the members of the Bar Association permission to act as privateers against American commercial vessels. Because the jurisdiction where they attack us is international, admiralty, and maritime commercial laws. And that's why you see the gold ranges around the flag, around that war flag, because the war flag is a war flag representing that the government is at war with the citizens. See 1864 Naval Agency and Distribution Act. Again, also, the United States was incorporated by the Pope, and the laws we are bound by are foreign laws from Great Britain, which means that the United States, the corporation, got Americans to bind by laws from Great Britain, which is also illegal. That's why, again, you have BAR, which stands for British Accredited Registry.
What page are we on?
I'm almost through now. I'm closing now.
All right.
Again, I am one change from jurisdiction of the courts. I have a higher jurisdiction. 2, I am demanding to see the state of Georgia to show up in proper persona. This must be made by self and not an attorney. 3, I am demanding that the courts present a living injured party because our citizens are considered dead entities, corporations, legal fictions, and artificial persons. 4, I am requesting the judge oath of office and the first and last name of every court official in this courtroom before we proceed. I am demanding to see who gave the courts permission to use the all caps trust, which is a copyright and trademark. I am putting the courts on notice that I have occupied my executive office again, and I am standing in my full capacity as American State National, and I hold the highest court here today. I am demanding you give me a full relief for my case by either dismissing this case or giving me a bid bond signed and paid through my all caps trust. I am also filing an order of pro se ex parte with prohibition to dismiss my case for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction. Your Honor, I, the petitioner, case are not being handled in the proper courts, which is common law courts. I, the petitioner, was not put on notice by a state-appointed attorney that my case was not handled in the proper courts. I, the petitioner, never signed a contract to be subject to the jurisdiction of the United States and or the District of Columbia. Again, the birth certificate and Social Security card are voidable contracts that was constructed when I, the petitioner, was a minor. So these contracts could have not been knowingly, voluntarily, or willingly consented to because as a minor, I, the petitioner, lacked the capacity to do so. Again, I am making a clear and unequivocal demand to petition the state to show up in proper persona. The state is a legal entity, and a legal entity is an artificial person. And an artificial person is a corporation, which cannot appear in proper persona. See case law, Penhollow versus DOANES. This vagueness doctrine may invalidate criminal law for 2 independent reasons. First, it may fail to get a proper kind of notice that will enable ordinary people to know what kind of conduct to prohibit. Second, it may authorize and even encourage arbitrary and discriminatory enforcement. Your Honor, a basic principle of due process that a law is unconstitutional if its prohibitions are not clearly defined. Plus, I, the petitioner, cannot owe a debt in a bankrupt nation, and no title of nobility shall be granted by the United States.
I can't owe a debt in a bankrupt nation.
Again, Your Honor, I, the petitioner, cannot have a fair and impartial trial when the judge, the jury, the bailiff, the district attorney, and public defender all work for the state and are one and the same. See the case law, the Maggie Hamlet case. Your Honor, the Constitution is a chapter of negative liabilities. Liberties, excuse me. It tells the state to let people alone. It does not require the federal government or even the state to provide services, even so elementary as maintaining law and order. See case law ID, period, CF.OLMSTEAD versus United States 277 US.438 and 478 1928. And again, Your Honor, any judge or magistrate who does not comply with his or her oath to the Constitution of the United States wars against that Constitution and engages in acts of violation of the supreme law of the land. The judge is engaged in acts of treason. See case law Cooper versus AURON, 358.
He's called for the judge's death for treason already.
78 CF.1401 1958. Your Honor, the authentication of my birth certificate signed by the Secretary of State, the Secretary of Washington, D.C., and the Governor of Georgia is admitting that the government made a mistake by making me to abide by a void contract and subjecting me to the jurisdiction and laws of the government when I had no knowledge of this contract and was too young even know that this contract exists, that the government tricked me and my parents into without our knowledge and consent. And the courts have a copy of my birth certificate authentication also. Your Honor, I am a private American, which is American State National, and cannot be represented by a bar attorney because an attorney is an officer of the court who will automatically subject me to the court jurisdiction.
And I hear you on that, which is why we had the first part of our conversation, and I've concluded that you've got the ability to and the desire to represent yourself. We'll do that. I appreciate you making that record. As you and I agreed, you won't need to do that again. You've now made all those objections, made it very clear that there's $1 billion plus, and I get it that that number is increasing. Every day you're in custody and people are trying to contract with you when they shouldn't, all that. You've made a healthy record of that. You are welcome to file things now because you are your own attorney. You can now file things of record into the docket. But when we see each other again for whatever the next court event is, we can use a shorthand where you can say, I renew the objections that I made on the record when I was last in court. And that way you're not going to need to break your vocal cords by going through that again. But that was very thorough, and I appreciate you making that record.
So is I can leave these motions here today?
So this one time, I'll take responsibility for filing things for you.
You know what, I'll wait, because I still have some other.
You want to do more work on it?
Yeah.
Okay. There is a way for you to file things from the jail, and they ought to tell you about that, but you can get things to the clerk's office. Don't mail them to me, because if you mail them to me, I'm not the clerk. They won't get in the docket. They go into my inbox, and I've got my Pierce collection. You should also know if you send things to me, I probably need to send them to the prosecutor as well, because we can't have what we call ex parte conversations. In the same way that the prosecutor can't call me and say, let me tell you what Pierce did. That won't happen. If Mr. Abate wants to talk about this case, you need to be in the loop as well. And so we'll bring you over here, or if it's real simple and technical, we'll get you in a Zoom booth so you can see and hear. But if it's anything substantive, you'll be here in person in open court for that. Okay? So what I see as our next steps, then I'll see if the prosecutor has anything else, and I'll see if you have anything else, is that I'm going to get a scheduling order in that gives a deadline for Mr. Abate to get together the paper discovery and then a list of what the digital discovery is, and we'll figure out how best to get that to you. I need to enter an order that says you get to represent yourself, so that's in there, and then we move forward.
Okay, cool.
What about you? Yeah.
Last time I was here when I went to trial, they had where I went to the law library and look at video footage. That's not possible anymore. Well, yeah,
I don't know. Meaning you went to the law library at the jail,
yeah,
and you were able to
They had an officer supervise me to watch the videos.
Okay, why don't you ask? That's a question you need to ask the folks out there. I don't control the sheriff's security protocol. They may still do that. They may have cut it off because someone said it's video footage and instead it was an adult movie or something. That's not you, but someone may have done something that abused that privilege. So ask, and if the answer is there's a way to do it,
not what the law library is for.
What I do know works, because I did it the last time I had a pro se defendant, is that he came here and we had a laptop. The prosecutor brought in a laptop and said, here's the directory, here are the 5 videos. Prosecutor went away and you hit play and you got to watch them. Took whatever notes you wanted and then you went back. So worst case scenario, we'll do that. But if you figure out there's a way to do it at the jail, then we can talk about making that work.
Who I need to contact? I think I need to contact the sheriff office, the sheriff or something.
It would be someone at the jail. I don't know who you talk to if you want to go to the law library or if you've got a headache and you want a pain pill. I would talk to staff out at the jail. Hey, if I want to do X, is there a way to do it? If they say there's not, then we got to do it over here.
All right.
Okay.
Understood.
Any other questions?
No, sir.
Mr. Abate, what do we have from the state?
So on the last issue you just, or Mr. Pierce just raised, I don't believe the jail does that anymore.
I don't either, but
the USB and the or CD, they just don't allow that kind of what they would call contraband at this point. So he can ask us, but just for efficiency purposes, I think.
Sure, with the law library, just see the law library still do it.
You should ask, but don't be disappointed if the answer is no. I think there were issues with, a USB drive is so small and it ends up in someone's pocket, and then it's on the 7 North. And I'm not saying you did.
Is it part of me possible I ain't got to tell you, they can stick it in, sit there, with me to watch the whole video.
Hey, if you can sell it and make them do it, that's great. I'm not saying no. It's not my call. It's not his call. That's 100% the chief jailer's call. And they may have said, we're not doing it anymore. And if they're not, then you come over here and we'll make it happen. Anything else?
No, Your Honor, I'll get paper discovery this week.
Great.
To Your Honor, and then I will, in abundance of caution, put all the digital media on the drive just in case.
Good.
And regardless,
Well, and that would be helpful, because if you include that with the paper discovery, then you don't even need to be in. If we can get our hands on a laptop, then, I mean, we'll let you know when Mr. Pierce is coming over, but we may not need to impose on you to show up with the stuff loaded on a computer. I don't know. I don't want to get in the middle of the technical stuff, but I do want to enable Mr. Pierce to see what the state has.
I have no problem logging in the laptop when he's here. We did that with Judge Ingram on multiple occasions, and it seemed to work pretty efficiently.
Good, I think so.
And Mr. Pierce is an ANC recidivist, so he is facing a convicted and mandatory life without parole sentence.
Okay, and is there a recidivist notice in the docket?
Not at the moment. I intend to file it.
Okay. Mr. Pierce, I'm going to translate that for you. You may already know what it means, but because of your criminal history, the state has the ability to file a pleading, which it sounds like they're going to do, that if you're found guilty, and all of this is contingent on a jury finding you guilty. If they find you not guilty, none of this matters.
Okay.
But it's a big if. And if a jury comes back with guilty, I had mentioned that the maximum possible penalty was life without parole. But if you'd never been in trouble before, that's not a mandatory sentence. Life, I'd have to impose life, but I have the option to choose between life without parole or life. Unless you've got sufficient criminal history and the state files this notice. And if they do that and they've got certified copies of your convictions, then that takes that discretion away from me. And the only sentence you can get is life without parole. And that may be where we end up, but they haven't filed it yet. When they do, we'll figure it out. But it's important that you be on notice of that, because sometimes the defendant thinks like, hey, you know what, if I'm found guilty, it'll be life. That's a long time, but it's parole after 30 years. But if life without parole is the only option, it just may make you think differently about the case.
We're in Georgia.
But we'll keep you posted. Okay? I appreciate everyone's patience. Mr. Pierce, we'll get you back here either because you filed something we need to talk about, or it's time for you to look at the digital discovery. All right?
So, question before we go.
Yeah.
How much do I have, like a certain amount of time to file all the motions that I need to file, or how do that work?
So there'll be a scheduling order that comes out, and we'll need to make sure it gets to you. And that's got a deadline for the state to get discovery. And then you've got a deadline after that, so you can see all the discovery to file motions. Okay. You can always file a motion later on. I just don't promise you that I'll get to it before we get to trial, because you don't want to avoid a defendant just before trial. It's like, oh, no, I got another motion and another motion. So you're going to want to start filing things. If you already have them here, put them down on paper and start filing them. But you'll get this scheduling order that's got the cutoff where anything filed after that date is out of time, and I can choose to ignore it, and I don't get in trouble with the Supreme Court.
Okay.
Okay.
And question, I know I've been having a conflict with attorneys, so does my time from this day today on forward start me to file my speedy trial? I know it's a certain time frame for you to file a speedy trial. So does that time frame start now, since we have an understanding?
Right. It started from when you were indicted.
But you're in Georgia. Speedy trial's 6
years. You can still file.
There.
You can file. Well, I'm not going to give you advice. You should file what you want to file, and we'll work through whether it's a mandatory speedy trial or if it's a discretionary one. But I'll tell you, no one's interested in slowing this down. Mr. Baker is on a trial calendar that starts in a week. Okay. And I'm having to slow that down because really you two ought to be tried together, unless someone can convince me that you shouldn't be tried together.
You're going to try it together even if I'm not a citizen?
Yep. We can try a citizen next to a non-citizen.
We've done that before.
The only reason you don't try people together is if there are reasons why there's some evidence that can only come in if they have separate trials. But I leave that up to the lawyers and you to work through that. My default is always to try co-defendants together. And Mr. Baker's case is ready for trial. So if you say, I want a speedy trial, no one's going to say, no, let's slow it down. They'll want to move it along. But you file what you want to file, and I promise you we'll work through it, okay? All right. Thank you, deputies. You can take Mr. Pierce back.
Wow. Judge McBurney's strategy on dealing with a...
Judge, as an update, success.
Good. Given how much time we just worked, you should have everything done. But thank you.
Yeah, working on that.
Judge, look all the work I got done while he was ranting.
Yes. Do we need to keep folks apart here?
I'll make sure that.
Make sure they stay apart. Thank you for sitting through that.
Mr. Rivers, you are.
But you know what? We got that out of our system. Who's coming out now?
Christopher Shanks. Can we do the Christopher Shanks?
Sure, yeah, that's fine. I think all we have left is Shanks and Cook. Is Cook a 2-minute conversation?
We're gonna bail on that one. All right. Wow. The judge's strategy in letting that play out, listening to the whole thing, just letting it all happen, and then saying, "Okay, I've got that. I hear you, and I understand that you're billing me $75,000 per hour, and that you're charging me $100,000 for the fact that we were not able to bring the victim who you shot in the head allegedly to trial to face you. I understand all those things, but we're moving forward. So in the future, just say, remember my last argument? Still there. I don't think it's going to work. I think we saw the defendant here today being very agreeable, just like, hey, it's working. He's going to go back to jail. And they're going to be like, no. His jailhouse lawyers are going to be like, no. They're supposed to release you right now. You don't have to go forward. There's no jurisdiction. Say no or make him do it now. And then in the next hearing, he's going to be like, nope, I refuse to go forward. That's my prediction there. Can we follow the trial? We'll watch for it. I don't know when it's going to be chosen. We watched Pritchett. Pritchett and who was his co-defendant. We watched those two together with Mr. McBurney. That would be a fun one. Let's see. People will people. Let me see if I can get the Maya counter working again. Hang on 1 second. I need to call my son because he made it. I'm going to see if my son who made the program can run it again because I can't figure out how to do it. Hang on, I'm following instructions here. Open what?
VS Code. This is the Mac, correct?
Yeah.
VS Code may not be visible there. You have to visit it through the Finder.
I'm getting tech lessons from my son. Hang on. Applications. What? Utilities. What?
VS Code has always been tricky to find. Hit Control Space or Command Space here on Mac.
Command space.
VS or Visual. It may not like the shorthand. Open that.
Visual Studio Code. Okay, I'm getting there. We're getting there. We're getting it running. Okay.
Once that runs, you've got it running. Go live.
Just go live.
All right, it's open. You visit the IP address of the Mac with the port 5500, and it will open the stream.
Okay, he's giving me some hard instruction. Oh, there it is. It's over there. 3. Does that look right? Does this look right to you guys? I'm not sure if it's right because it passed into the new year. What's up?
It is not set up to calculate interest compounding over the year yet.
So it's missing last year's interest. This is just this year's interest.
It has the interest, but the interest should have compounded. Once you hit the year mark, it should have been including interest as compounding.
Yeah. All right. So that's probably not accurate. You'll have to fix it. So, okay. Thanks. So the counter still exists, but it's not set up to calculate the compounding interest year after year. So there's that. It was just a simple program he wrote, but my kid's much smarter than me. So, all right, raising incredible humans. He's really smart. He loves. He's doing machine learning stuff in school right now. So basically, computers becoming smarter than everyone else. Oh.
No additional information.
No.
The
I didn't tell you about the
just
role.
pops in.
I didn't know
getting
who
to
it
that.
was.
I'm getting to that.
This just popped
because
in.
that was the next conversation that we had. When we were told on the day of closing
This just started right
to
now.
approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors, or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously recognized
You were not,
that.
just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury?
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember, no. That was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required. Period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has...
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us. We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again, that's news to me.
You were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told...
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time, in good faith. Both Mr. Yannetti and I asked the court to take evidence from Lieutenant Fanning. The court
I think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So, of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access, he didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So, now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
So we will move on from that, Mr. Jackson. We'll move on from that. So
well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew he ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror. That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper, in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
All right, so that's your answer to my question.
That's my answer to
May I have a
the
moment
question.
to confer with counsel?
Yes.
The judge says, I don't like your answer. AJ has a very, well, a point that he's able to argue quite eloquently. This is why. She's like, but why'd you put that in? You knew before. Nope, I did not. We didn't because you wouldn't allow us to know. Deep sighs from the judge. She's already been breathing in her microphone several times. I told you today was going to be spicy, and it is. It did just, I'm not sure how much we missed, but it just barely came up. Weather's been a factor, I think. We'll blame that. So now Mr. Yannetti and Mr. Jackson are talking this over before they move on.
For that,
see if they
the
can do
court
anything
invoked
else.
Mr. Yannetti and said, as local counsel, he knows this not to be true. Mr. Yannetti just indicated to me that that's not quite the fact. And so Mr. Yannetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yannetti. So if the court would allow Mr. Yannetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
I'm happy to, Your Honor, and thank you for giving me the opportunity. The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Sallyport videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sallyport issue, or the Sallyport video
There's
issue.
another siren.
The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of D.G. Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious, so he's still around?
He is,
Okay.
yes, and he's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations, And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Kenton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Sally Port interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sally Port. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sally Port interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D. Giampetro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us. It's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sally Port video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick dated February 28th, which is 4 days ago, 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. Exterior Sally Port. That means that the Massachusetts State Police not only had in their possession exterior Sally Port video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025, and they've now admitted that. But who else knew about this withheld video in May of 2024? during trial. On cross-examination...
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly?
Same.
Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024 because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute, on April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the Sallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through
now
my
or no. If you can, if you're going to do it later, that's fine.
I will
if
do
there's
it later.
time,
I will
if
do
we
it
have
later.
time.
I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay.
It just, very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true, and we're still getting video evidence that is in their possession, custody, and control in October, in January? How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But at the point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it? What page
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs.
Okay.
Crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. That's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote-unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sallyport, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? the defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance, the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sally Port. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, while they were battling us on the time that it got there. No, the defense is all wet, they're wrong, they just didn't account for daylight savings time. Oh, no, this was just a little mistake, it's not a big deal, it was a Scrivener's error, and the entire time they're making both of these claims, they had video in their possession that established unequivocally that car was in Michael Proctor's possession at 5:30 and pulled into the Sally Port at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sally Port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it, it's their struggle to acknowledge it. Of course that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sally Port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally Port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. This is not a game of Wordle. This is not something that's supposed to be parsed.
Bingo.
All physical evidence be preserved. That's pretty straightforward.
Wordle
the
of the
Commonwealth
day.
shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sally Port videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways. They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sally Port until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sally Port video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581, and this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor.
Okay.
I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchanan. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact. By his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C is in Charlie.
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. It hasn't been years. He further admitted that it shows the SUV arriving in the Sallyport at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly two in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry?
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton Police video system. We were not told that until well after trial. That was never disclosed to us, and I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed to as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote-unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument, I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably
an hour.
45 minutes, I would say.
All right, so we'll break.
She does not like him very much. Can you tell? That was our we're going to lunch. The judge is walking out of the courtroom. Yes, it's lunch break. I have to go to the post office during break, but we're going to come back. These are the spicy arguments, and we're going to have, or I think we're going to get multiple. I think we're going to hear from Miss Little. I think we're going to hear from Yannetti. Everyone's supposed to sort of condense everything down into one big argument for this motion to dismiss based on the extraordinary government misconduct. So, Sinksy 1212, welcome to the gallery. You've changed your name, I think. Sinksy, what was your name before? Or did you just fly under the radar this whole time? I think that's the first time I've seen that profile picture. So, all right. Welcome. Report's motion activated. If so, there should be 24/7. There would not be 24/7. There would not be. But you'd think moving something the size of a car in would probably trigger it. She'll deny it. Probably, most likely. She has asked a couple questions that would be at least indicate that she was going to look deeper into this. And she asked the state about a certain employee who performed some sort of function or testified to something and asked if he was still available, meaning that maybe that's something that we need to look into. But we'll see if that happens. If Reed gets a mistrial, are they going to see who really killed him? Spooky wife, if Miss Reed gets a mistrial, that she did get a mistrial. That's where I'm a little confused. The judge ruled that the jury was hung, and that is a mistrial. That's why she's getting a new one. If she gets acquitted, or if this case gets dismissed, it does nothing to advance in and of itself the solving of the case, answering the question what happened to Mr. O'Keefe that night. There may be more evidence later down the road that shows one way or the other, but need a lunch break to talk to prosecution? No. I think she wants to get away from everything. We're done with Karen Reed until after lunch. When we come back, we've had a couple of cases that we're trying to follow that have been problematic this week. So 3 of our options are out. So we're going to follow this a little bit after lunch as well, because it's going to be the spiciest arguments, and then we'll wait and see what the answer is. This could be dismissed with prejudice. Is that right? Yes, it could. It could be dismissed on 2 levels. It could be dismissed from federal court, where they just had a hearing this morning. Obviously, that's not televised. And it could also be dismissed at a local level here. The judge could dismiss it with prejudice. That's one of the options that's available. It's what the defense is asking for in this motion. You don't like AJ or the fact that he's good at what he does? I like all of them. I even like lawyers that we love to hate a little bit. like a spicy argument in court. I like it to be, I like them to fight valiantly for their side, to really put in their best effort. So, all right. So I'm going to make we'll make a quick portal. If I can, there we go. We'll do a portal till the afternoon. She just went to lunch. It is 1 o'clock. So we're going to come back at 2. Possibly a little bit before then. And there it is, Karen Reed. Okay. All right, timeline. All right, we're all set up. We're good. Do you know this afternoon we have storms coming in my area? Oh, that's not the right song. There we go. We have storms coming in my area, so fingers crossed that everything keeps working. I might have to set up the Starlink and run off generator power if we're going to continue. But AJ's good. Yannetti is good. Alessi is good. Brandon is good. Lally's good in a different way. What, if any, way are you talking about? Well, he's good. He's just not the way that I like. Even the judge is good. I like a judge with personality, and Judge Beverly Cannoni has that. Not always agree with her decisions, but I like her as well. So Miss Little is good. Yeah, don't miss Miss Little. Jewel says, you're wrong. You're wrong. I've been wrong before. It's all right. If you run off a generator, is that like camping? It is camping, yes. AJ fights for his client. Does not fight for the truth. It's not the defense attorney's job to solve the crime. It's the defense attorney's job to hold the state to their burden. And sometimes that means, that somebody who looks pretty guilty gets an acquittal. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 1 hour here with the afternoon. The spice continues. I think Judge Beverly's going to turn it up a notch as she gets a little bit tired of the long-winded nature of this argument, where the Commonwealth is being raked over the coals by the defense. They're asking for a full dismissal with prejudice. We'll see what happens. Guys, see you after lunch. Bye-bye. Oops, I haven't made the...
Thank you, sir. You're my new best friend.
Haven't made the portal yet, so we get to stay here for a second.
I was kicked back, taking it easy.
Creating a portal right now. Click, click, save. Portal's created. We'll see you guys in a little bit. Oh, no, I need the outro.
Shame on you, sir.
I know. Messed everything up. 3, 2, 1.
Have them send someone with more experience.
Because he's the guy.
In front of the wall.